Recently, we had a client who was charged with DWI. She had never been in trouble before, married with kids, does a lot of work in the community. She had been at dinner with some friends, had a couple of glasses of wine. When she got up on the freeway, she was using her turn signal, she was doing the speed limit, but somebody was tracking her, following her, almost tailgating her, and it freaked her out. So she speeds up, now she's speeding, and then she makes one final lane change without using her signal. She gets pulled over for those traffic violations. But when they pulled her out of her vehicle, now she had not admitted to drinking. The first officer does the HGN or eye test. He wasn't sure about his results, but then he's already called a tow truck to come tow her vehicle. A backup officer gets to the scene. He redoes the HGN or the eye test, and he tells the first officer, I got 6 out of 6 clues. So they handcuff her, tell her that she's detained, not arrested, put her in the back of the patrol unit, tow her vehicle, and move her off the freeway to a safer location so they can further investigate a DWI. At this point, we didn't feel like they had enough to take her liberty, her freedom away from her, handcuff her, put her in the back of the patrol car, and tow her vehicle. So we set the case for a suppression hearing, which in a suppression hearing, what we're doing is asking a court to evaluate the evidence, listen to the testimony, and determine whether there was enough probable cause to make the arrest or to take her freedom, her liberty away from her at that point. Before we had the hearing, a chief prosecutor reviewed the case and decided to dismiss the case, saying that there was not proof beyond a reasonable doubt. So in 2 years, she'll be eligible to have the arrest expunged off of her record. It was a long road, and we're very happy that she was able to have closure in this situation. If you go to jail, call JL 713-201-6767.